Good morning. Tom Salad. Jeffrey I'm surprised you had to ask me then.
He still wants to go as zone for the moment. It should be the other way around. He wants to fire you later. He can fire you. Right now it's up for me. That's a good point. Have you found anything? No, didn't find anything. We were asked last week before we could get in the case. I objected to the psychological exam. Did you follow the capacity to see your we filed we filed the memo and this and the citation, so that's where it goes.
Yeah, this is the, we cited this.
Defender, conflict now, conflict if you do well, you notice two different conflicts. Here's what I did. And he filed it. He didn't tell me not to come, so that's why I said, but I'll step back. If he told you to be here, that's probably research notion. This is a well-researched notion. I didn't read it all.
Okay, good morning, everyone. Just want to remind everyone about their cell phones, please protect them. Make sure they're either turned on or on silent. If you get a phone call, you need to speak on your phone, please feel free to get out and walk out the door, handle that, and then you're more than welcome to come back in the door again, but please do not be that important. Thank you.
Right. Circuit Court of the United States Circuit and Orange County Court is now open. Justice Brennan, Taylor, Chief Judge presiding.
All right, have a seat, everybody. Well, good morning. We're on the record in State of Florida versus Markeith Loyd, 2016 CF 15738, 2017 826. Mr. Loyd, good morning, sir. How are you? Mr. Loyd, we have a number of matters that we're going to take up this morning. You are entitled to be represented by counsel, as we've discussed previously, and if you cannot afford an attorney to represent you, I would appoint one for you. Is it your desire to have me appoint an attorney for you, or do you wish to represent yourself this morning? I'm going to appoint standby counsel in this matter. Pardon me? I did, sir. Yes, I did. Thank you. I'm going to appoint standby counsel. The Public Defender's Office has a conflict. Mr. Dean, I understand that you filed a conflict on behalf of your office. I've asked Mr. Whedon to come over this morning. He is on the wheel or the list. Mr. Whedon, I'm going to appoint you as standby counsel.
Yes, sir.
And I'm going to also appoint Candace Hawthorne to assist you. If Mr. Loyd chooses to have counsel, my intention is you would be the lead. And she could co-chair the matter with you. She's not here. I have to confirm that she can accept the appointment. Can you accept the appointment at this time, sir?
Yes, Your Honor.
All right. And then I would like... Yes, Mr. Dean? Yes, thank you, sir. If Mr. Loyd changes his mind as lead, you're going to have plenty of work to do. I would ask Ms. Hawthorne to begin to prepare mitigation evidence if the state files a notice of intent to seek death, which I don't believe has been filed yet. So right now, I just want her to be available to you if the situation changes.
Yes, sir.
You understand where we are?
Yes, sir.
All right, very good. At the last hearing, Mr. Loyd mentioned to the court that in the course of his arrest, he sustained injuries to himself, including that he is experiencing headaches, that there was trauma to his head. Mr. Loyd, you've behaved well in court in front of me, but I have a question in my mind as to your competency, although I have found you competent to make the decision to represent yourself. In an abundance of caution, I'm going to ask Dr. Danziger to examine you for your competency. I know you do, and I received your pleading, and I respect that you've objected. He's going to come out and talk to you. I understand your position. Just bear with me for 1 second. He's going to come out and talk to you. I can't force you to speak to him, but I would ask you to speak to him. And he will examine records that are available to him, and he then will report back to me, and I'm going to ask him to do this within the next 15 days as to your competency to proceed in this matter. And I received your objection to that in writing, and I've reviewed it, and I appreciate that you object, but I'm going to make that appointment regardless. In the state, I appreciate the memo that you sent to me, and I've reviewed that also, Mr. King.
If I could just clarify, are you appointing somebody for competency to stand trial?
I'm going to have him examine as to both. Predominantly competency to stand trial, but in the course of that examination, I think I'll get information that will assist me in the decision I've made to date, which is he competent to make the election that he has made? I have found that he is up to this point in time, but I would like Dr. Danziger to review that in light of the statements at the other proceeding that maybe there was trauma to Mr. Loyd, including maybe neurological trauma. I don't know for sure because I'm not an expert.
And the only thing I would suggest, Your Honor, is that Mr. Danziger,
Dr. Danziger.
Dr. Danziger, be informed by your order or otherwise to inquire into what Edwards versus Indiana says, serious mental illness, which is also part of the standard in competency to represent yourself.
Have you used orders that has language that you prefer in it? In other words, you want to submit that to me? I can do it. I mean, I'll have him examined as to his competency to proceed, whether he has serious mental issue and health issues, and also in doing that, I think I'll receive some expert conclusions about Mr. Loyd's competency to choose to represent himself. As I've said, I've already found that. But,
yes, sir. I can certainly do a proposed order and share it with Mr. Wheaton and Mr. Loyd.
All right.
And
why don't you do that? I would appreciate that.
maybe, if not by at least, I can do it this week, and maybe by next Monday when we meet again, if we do, if there's any questions, we can resolve it.
All right. I appreciate that. The other matter that we have from last week was my indication that Ms. Ayala's motion to stay proceedings would be argued today, so I'm prepared to hear argument on that matter. Ms. Ayala, how do you plan to proceed? I received a pleading as I arrived at work today, a motion on your behalf. Let me just flip to it. From Mr. Hasbin. Is that how you pronounce it, Hasbin?
Yes, Your Honor.
Is he here?
He is not. Again, Aramis Ayala, State Attorney. I do have counsel here who is wishing to be admitted pro hoc vici. That is Mr. Austin, but there is another attorney from their firm if the court would like to hear from Mr. Austin at this time.
All right, Mr. Austin, come on up for a moment. Good morning, sir.
Good morning, Your Honor. Roy Austin on behalf of State Attorney Aramis Ayala. Your Honor, it is our position that the governor was not in a position, did not have the lawful authority to replace Ms. Ayala.
Let's talk about, before we get into argument, let's talk about your admission, because I think we should take it in that order.
All right. Well, let's
Okay, very
get
good.
admitted first then, Your Honor.
Yes, sir.
You have before you, I believe, the pro hoc vice motion for admission.
Right now, unless something's been filed this morning I haven't seen any motion other than the motion to stay the proceedings. I haven't seen an original action for quo warranto. Is that
May I?
being filed or about to be filed?
It will be filed shortly, Your Honor. We first want to determine who's representing the state with respect to this proceeding here.
Mr. King?
Your Honor, I hate to keep interrupting, but it appears to me that when we were here last Monday, I filed with the court clerk the original copy with a gold seal of the governor's executive order appointing me. At that time, the court accepted that executive order. By all of the cases I cited, all Florida Supreme Court cases, that filing creates a presumption that I am the acting state attorney in this case. I think counsel even conceded in their supplemental motion that the way to attack that is by quo warranto. So if they choose to do that, they certainly have that avenue of attack. But from the time that that executive order was filed with the Department of State, my position is that's what's required under the statute. That's what gives me my authority. And it being presented to you creates a presumption that I'm the appointed state attorney in this case.
So one of the things that I'm questioning is just the order of matters. if Ms. Ayala files quo warranto, I'm questioning in my mind who needs to be served, who is the other party, and it may be the governor.
I think the governor would at least be one of the parties.
Right, and then it might be the Attorney General, I'm not sure who,
Well, I
or
think
General
also-
Counsel, or you, I'm not sure.
Not to throw myself into that briar patch, but yes, sir, I believe that part of that would be the quo warranto would be as to myself and the governor.
Right. At that point, I could consider Mr. Austin's appearance pro hoc vice to represent Ms. Ayala in that matter if it were to happen, but it just hasn't happened yet. And so we're, in some ways, we're putting the cart a little bit before the horse because I don't have that proceeding.
Respectfully, Your Honor, maybe?
Yes, sir.
Yes. I don't believe, first of all, that we have ever said that
But
Mr.
Your Honor,
King...
just a point of order, Your Honor, not to be impolite, but we still haven't determined Mr. Austin's
Authority.
right and authority to be here to speak.
I'm going to give a little leeway to see what he's about to present to me. I understand your objection, and there are a number of balls up in the air right now. If you'll just bear with me a little bit, let me
That's fine.
hear his position, and then I'll make some decisions as to what direction we're going. Yes, sir.
Yeah, thank you, Your Honor. Quite simply, there's nothing in the case law that indicates that there's any presumption that what the governor did in forcefully removing Ms. Ayala from this case...
I'm not sure I agree with that. I mean, I think there's some cases about the governor's authority to substitute state attorneys for another state attorney. There are cases that address that.
There are, Your Honor.
Yes.
When there has been a disqualification. Never based on what is purely a policy decision. Unless this court is willing to say that every state attorney in the state of Florida is required to seek the death penalty in particular cases, then what the governor has done here is, in essence, a policy decision, which there's no court in the state of Florida that has ever said that a governor is, in fact, allowed to replace a state attorney when she is exercising her prosecutorial discretion. Based on that alone, Your Honor, what the governor has tried to do here is something that is both unconstitutional and illegal. And you have the authority to manage your courtroom and your cases. And here we have a case which Ms. Ayala's office has spent months on, working through. And the continuation of that is what is more important. And there's actually no reason why the governor could not file quo warranto and say that he wants to replace someone.
But isn't the procedure in Florida somewhat clear that if you question the authority of the governor to act as he did, you need to bring an action, and that action in Florida is quo warranto. And that hasn't happened yet, and it seems to me you're asking, may I be appointed pro hoc vice to pursue that avenue? Is that what you're asking?
I'm saying, Your Honor, that the governor did not even have the authority to do what he did, and the court could find that at this time without the quo warranto, because it is so clear on its face that the governor overstepped his bounds.
All right, what are you asking me to do as it pertains to you?
As it pertains to me and as it pertains to the case in front of you, Your Honor, we're asking you to make sure that Ms. Ayala is the state attorney of record in her courtroom, in her courthouse, until the quo warranto is decided, and to stay the proceedings with respect to this case until that is decided.
How, are you licensed to practice in Florida?
I am not, but I am seeking admittance pro hoc.
So that's the first matter, right?
Yes,
In other
sir.
words, with all due respect, if you're not licensed to practice here and I don't grant your permission to appear pro hoc vice, there's no real grounds for me to hear your argument. So it would seem to me we have to take it in that order. Can you appear pro hoc vice on behalf of Ms. Ayala? And that's what you're asking me to decide?
And I have here present counsel from Zuckerman Spader here in Tampa, who is also on this pleading, who I am working with respect to this case. So we do have Florida counsel here, Your Honor.
Well, I understand the proceedings for pro hoc vice appearances, but really I have to make that decision first, with all due respect, before I can really even entertain your matters, because you're not licensed to practice law here, and I have to grant you the authority to make these arguments.
Certainly, Your Honor, but I don't know that that's a particularly high hurdle with respect to whether or not my pro hoc vice is, and I don't know if the state objects to my seeking to.
I'm going to find that out in just one second. So I know we're the order is a little unusual right now, but as to Mr. Austin's request to appear pro hoc vice, I believe to bring an action quo warranto, I think that's what he's argued in his motion. Do you have a position on that, Mr. King?
Yes, sir, I do. And part of it's technical.
Okay.
But I think technical is what the law is often all about. Firstly, a matter in quo warranto is a civil matter to be filed in a civil case. Obviously, we're here in a criminal case. So if he should be admitted pro hoc vice, which I don't contest, I do contest that he be admitted in this criminal case to do that. And secondly, because this is a criminal case, I have the concern, the notice of appearance that Mr. Austin filed was a notice of appearance to represent Ms. Ayala, not to represent the state of Florida or Mr. Loyd, the only two parties to this criminal case. To represent the state of Florida in a criminal case, you have to be either a state attorney or an assigned state attorney or an assistant state attorney or an assistant to the state attorney. Mr. Austin qualifies for none of those four positions. So in this case, he is without the basis to be able to be appointed pro hoc vice in the criminal case to argue any kind of motion.
Ms. Ayala.
Judge, if I can be heard, thank you again, Aramis Ayala, State Attorney. It's my position as a State Attorney that it was necessary for me to have counsel to file the quo warranto.
All right.
Because that has to be filed with the Supreme Court of Florida, Your Honor, in this criminal proceeding needs to be aware of what is going on because the issue is who is representing the state in this cause of action. It is my understanding that there's nothing that prohibits this court from making a ruling of who is the proper state attorney despite the governor's order. So it is my position that regardless of the admissions at this particular time of Mr. Austin, that I'm still presenting to the court as an individual, as the prosecutor of this case with Markeith Loyd. It is my position that the governor's order is unlawful, that it doesn't have a valid basis, that it is not constitutionally based, and it doesn't have bearings. So because of that, I have a responsibility to file it in the Supreme Court, but at this point, I also have a responsibility to Your Honor to be aware of the proceedings. Because I'm not doing the quo warranto myself, it was necessary to bring Mr. Austin into court through the local counsel to advise this court of exactly what the arguments were to give you the leisure and Your Honor the ability to make a ruling based upon that. But it is my request that the court stay these proceedings so that we can deal with the issue upon the filing of the quo warranto.
Excuse me, I want to speak.
Mr. Loyd?
I want to speak for the record that Governor Rick Scott, you can remove Mr. Allen for no valid reason. By law, the decision to seek the death penalty within the discretion of the state attorney. Because Mr. Allen didn't seek the death penalty as John Meehan wanted. And Governor Rick Scott stepped right in and took off the case for no reason at all, but to appoint the state attorney that would seek the death penalty for him. This move is clearly prejudiced, vindictive, and politically motivated by Governor Rick Scott. So there is no need to wonder what the new state attorney, Brad Scott, comes to do. He comes to do what Mr. Ayala didn't do, and that's to seek the death penalty. The governor has been on TV numerous times stated I should face the death penalty, as well as John Meehan. Well, how could he appoint anyone to my case, or get involved in my case when I've been tried and convicted in his eyes? He doesn't seek justice. And Rick Scott seeks revenge, not justice. So there's no need to wonder what Brad King comes to do. He comes to seek the death penalty, but Rick Scott wants him to do. If he's been stating all on TV, all on different news stations that I deserve the death penalty.
All right, thank you, Mr. Loyd. All right, thank you. I'm going to take up matters in this order. I want to hear argument about the motion to stay. I don't need a lot of argument because it's been brief, but I want to hear argument about that. Ms. Ayala, I'll permit you to argue that. I'm going to rule on that. In ruling on that, I'll indicate who I believe represents the state in these proceedings. I'll then take up the motion for admission pro hoc vice and talk about quo warranto. So let's talk at this point in time about the motion to stay the proceedings, and I'll let you start. Mr. King, I'll let you start.
All right, again, Aramis Ayala. Judge, it's my position that the governor's removal of me as state attorney from this case is unlawful and it's unconstitutional. It is my position, as outlined, though signed by Mr. Austin, that the proper venue and the proper vehicle is quo warranto. I would need about 14 days to file that in its proper venue, and during that time, there is a process that the court can stay this proceeding so that we don't proceed with the wrong state attorney, because based upon the research, there's very little support, if any, in the governor's position. There was not a process by which he made a determination of why he was removing from the case. There was a decision that was made. I was not advised directly of that. I was not questioned as it relates to the exercise of my discretion. Had I had an opportunity to tell him, I would have given him the details that I did go through the aggravators, that I did speak with the family, that I did review the file, that I went through every aspect on this particular case as well as every other case before I made a public announcement. And based upon that, then I looked at the prior cases that we have for resentencing and the chaos that has created, and made a decision based upon several factors, including those that I announced publicly, that it was not in the best interest of justice to move forward at this time with the death penalty. Specific to the prosecution of Markeith Loyd, I did everything that was necessary as it relates to the death penalty in reviewing the factors of whether or not I was going to proceed. So there has been no violation of my duty. There has been no dereliction of my duty. There has been no misrepresentation. The only thing that is done is I've acted within the bounds of the law, and I have done what I need to do and made the decision that I am not seeking death in this case. The governor then decided that he was going to make a public statement prior to contacting me and requesting that I recuse myself. I made a decision that I'm not going to speak publicly prior to speaking with him privately, and I reached out to him. I spoke to him. I asked the governor, did he have any questions? Would he like to understand my reasoning? He said, no, I just want to know you recusing yourself. The conversation was less than 25 seconds. From then, I understood that he replaced Mr. King. I was not noticed of it outside of the media and making a public announcement. And based upon the process that we have how we got here, it is inappropriate. The Constitution and the level of discretion that has been given to me as the state attorney does not authorize the governor to come in and remove that discretion. And the court will also see that was filed in the exhibit that the governor's office has also made that statement in 2016, where they notified another citizen of the state that the governor does not get involved in the discretionary aspects of the state attorney's office, that they are an independent body. That came from the governor's office less than a year ago. So based upon his prior statements, based upon the Constitution, based upon my discretion and my following the law and the procedure on this, there's no lawful reason to remove me from the case. Based upon that, I understand Your Honor is in a situation where a clock is still ticking in the criminal matters. But before we can allow that clock to continue, the interests of justice require that a ruling be had on my authority and my ability to prosecute the case in my jurisdiction that my attorneys in my office have been working on, have investigated, have reviewed, have indicted, have built a team and done the work, and we're on a clock. So based upon that, I think that it is in the best interest of justice so that on the back end, we don't have the wrong attorney prosecuting this case, since the governor does not have a valid reason to remove me. So based upon the long-term effect, based upon the unlawfulness of the governor's position, it is my request that this court stay the proceedings until the quo warranto has been filed and that we can get the ruling that I am the lawful attorney on this case, and I would ask for the court to give me approximately 14 days for that.
All right, thank you, ma'am.
Thank you.
Appreciate it. Mr. King.
Your Honor, while Ms. Ayala sets out a litany of facts to suggest that the governor's executive order is unlawful. The only fact that exists in this courtroom at this time is the filed executive order signed by Governor Scott, filed with the Department of State, and then filed in this court last week. Now, Florida Supreme Court is very clear about the process when that happens. And it goes all the way back to 1940, the cases that I cited in my brief. And it should be noted that in the first case, Johns versus State, the governor's assignment order begins by saying, whereas for good and sufficient reasons made known to me, I think the ends of justice would best be served by assignment of another state attorney to discharge the duties of the state attorney of the Third Circuit. And the appointment went to the state attorney of the Second Circuit. The Florida Supreme Court in Johns said that the filing of that executive order with the exact same language except for subserved instead of served creates a presumption of the legitimacy of the order and my authority to act in this case. And that's really where we're at. There is nothing else. There is no other fact. All of these things that Ms. Ayala speaks of are not facts. So you're left with the proceeding as it exists, that presumptively I am the state attorney. Now, I guess the suggestion she makes is give me 2 weeks. But we have to recognize that those 2 weeks come at Mr. Loyd's expense. Now, if he wants to join the quo warranto, he can do that. If Mr. Austin wants to represent Mr. Loyd in the quo warranto, he may be able to do that. But that's all a separate proceeding. And the Florida Supreme Court cases are clear that you cannot collaterally attack the governor's executive order in the criminal case. So you can't file a motion to stay because she has no authority to do that. And that was the purpose of my motion, to either strike it or telling the court I'm withdrawing it because I'm the attorney that represents the state of Florida in this case. And she can go to the Tallahassee, to the Supreme Court, file the writ, court can decide, and that's the way the process is supposed to work.
In your research, does the writ start at the trial level or does it start at the appellate level?
I would suggest there are some cases that I did not cite that say that the writ can start at the trial level, but I still believe it has to be filed in a separate civil case.
All right, I understand that.
Excuse me, Your Honor.
Give me 1 second, Mr. Loyd. I'm going to go in order. I want to give Mr. King the opportunity to complete his argument, and then I'll let you respond. Yes, sir.
That really, Your Honor, is the extent of my argument. What you have before you is a valid, on its face, executive order. All of the court cases say that that's all the governor has to recite, is that for good and sufficient reasons, he believes it appropriate to do.
All right, thank you, Mr. King. Ms. Ayala, I'm going to give you a chance to reply. I'm just directing traffic.
Yes, sir.
Do you want to wait till Ms. Ayala responds? You want to talk
You
now?
know, what he just said about good and sufficient reason, Governor Scott filed executive order or whatever. But what he couldn't say what he filed order for. Because in this case, he filed because she used her discretionary and it didn't agree with what he wanted to have. So what did he do the executive order for on the last case? What did other state attorneys do to get put out? But she didn't do anything.
All right, thank you.
By law, she used her discretion. He took her off because he wanted the death penalty. So he put Rakeem here to see the death penalty.
All right, thank you, Mr. Loyd. Ms. Ayala.
Judge, the facts, as I outlined, are ones that I'm personally aware of, I understand Mr. King wasn't there. But the one thing I do want to remind the court and distinguish, the 1940 cases and all of those, they predated elected state attorneys. So in 1968, when the Constitution allowed for elected state attorneys, that put the voters in a position to determine their state attorneys and the exercise of it. So the governor utilizing his authority to withdraw lawyers was prior to them being representative of an electorate. So I think there's a very clear distinction between the 1940 cases and those now that I think the court should consider.
All right, thank you, ma'am.
Thank you, Your Honor.
So the exact facts in this case are somewhat unique to the court. I'm not aware of a situation with these exact facts, but that's not unheard of in the law. That's how the law progresses. It's understandable to the court that some may question the authority of a governor to replace a popularly elected state attorney with another circuit state attorney, especially in a case where the replaced state attorney has announced her decision not to seek the death penalty either as it pertains to this case or as a matter of policy. And some may argue that the local state attorney should have to answer one way or another to the citizens in her circuit for her announced position. However, the case law that exists in this area is relatively clear. And the governor of the state of Florida, as the chief executive officer of the state, is empowered under Article 4, Section 1A of the Florida Constitution to take care that the laws be faithfully executed. The governor is given broad authority under the Constitution and particular authority, specific authority, under Florida Statute 27.14 to assign another state attorney to this circuit according to the case law upon a general recitation of his reasons for doing so. Much like statutes, the governor's action in this matter is presumptively constitutional. It's presumptively legal until, under the case law, until in an action in quo warranto, the court were to determine that the governor exceeded his authority. The logic for that is understandable in that two separate prosecutors with competing positions can't represent the state of Florida in the same manner, or it would be chaotic. The case law seems to require that the governor state that there is good and sufficient reasons, I use that in quotes, to order an assignment of another state attorney. The governor in this case fulfilled that obligation on March 16, 2017 in his Executive Order 17-66. The governor further complied with statute by making the order effective for 1 year. He filed that with the Secretary of State. He filed it here with the clerk of the court. In light of the only law that I could find in this area on this point, it's the court's conclusion that Ms. Ayala, a popularly elected state attorney for the Ninth Judicial Circuit, has been removed from this case by the governor of the state of Florida, who presumptively has the power to do that. And therefore, I'm denying Ms. Ayala's motion to stay the proceedings. And as has been pointed out here this morning, the approved process for reviewing the legality and the adequacy of the governor's order is through quo warranto, which is a somewhat obscure Latin phrase, but it's the procedure that would be brought in a court of law to question the authority of the governor to take the actions that he did. And that petition or that writ has not been filed as of this point in time. Ms. Ayala, I respect you personally, and I certainly respect your office, and I acknowledge that this is unheard of. I'm not aware of anything like this before. But it's my responsibility to determine the orderly progress of this case, and I find that Mr. King now possesses the authority of the state of Florida to prosecute this matter. I'm denying your motion to stay. The quo warranto, if it is filed, and if I preside over it, I am likely to allow Mr. Austin to appear pro hoc vice. I'm inclined to go in that direction if it's assigned to me, or if I take it because it makes sense to have the same judge presiding over the matter that's so related to this. But it might not even go that way. It might just go to a civil division. I'm not sure. I possess authority or jurisdiction over the criminal case, and I can sit and hear the civil matter at the same time. Mr. Loyd's speedy trial time is ticking away, and even a brief stay under this sort of truncated situation that we're in, which is that a lot of time has gone by already, I think is such that it would prejudice Mr. Loyd were I to stay this matter, and prejudice the state. I think it would be prejudicial to both. As I said, there can only be really one authorized prosecutor, and at this point in time, unless a court rules otherwise, I find that to be Mr. King. Ma'am?
Just a point of clarification.
Yes.
Respect the court's order, we'll move forward with the quo warranto. There's been, logistically, there's been some discussion on the attorneys. I want the record to be clear of how we expect to move forward.
Yes, ma'am.
I have attorneys in my office who have been assisting, and I believe Mr. King would like to stay on the case, despite them being my assistant attorneys in my office. So I want to make certain that we're clear whether Mr. King is going to have a team out of his office, whether he is requesting a team from my office, and how we plan on moving forward so that we remain.
Do you really need me for that, or is that a matter you just want to discuss internally? Unless there's some dispute about it, I'm not sure that's any of my business.
We don't, Your Honor. It's just that I would have to appoint them as assistants.
Right, under the statute.
But the other point of clarification, you made reference to motion, and I think we all know there's actually 2 cases and 2 motions.
Yes, so this order applies in both the 2016 case and the 2017 case. All right, I appreciate everybody's arguments and appearances. There's a little bit of work left to be done, and that's just status matters and housekeeping matters. So I have received from Mr. Loyd a notice or a motion for discovery. Have you received that?
Yes, sir, and we are working to fulfill that.
All right.
I've also spoken to the jail attorneys to make sure that when I deliver it, it's going to be in a format that they will accept.
All right. And then this morning, I received Mr. Lloyd's objection to my considering him, an evaluation for him, but I've ruled on that already. I don't know right now that there is another pending matter that I need to address, but I invite Mr. King, you to tell me if you think there's something for the status that we need to talk about.
I don't think there's anything that's set for today. I would advise the court that I will file probably when I get back to Ocala a motion for a DNA specimen, which I understand we have another status set Monday the 27th at 9, and I was just going to set it for hearing at that time.
Right, we have actually, I'm not sure I had a status set for Monday. Ms. Washington, come on up for a second. All right, yes, we do have a status. I apologize. I've got my dates confused a little bit. So it's at 10 o'clock next Monday.
10 o'clock.
And then at some point, I presume you're going to advise the court whether you intend to seek the death penalty or
Yes,
not.
I will do that this week as well.
Okay.
I'll file that.
Okay, excuse me. Mr. Loyd.
We already know he comes this week, he ain't got to wait till he can file that now.
Well, it's his, that's his choice, so he'll,
Anyways, like I said, I object
yes, sir.
to being appointed counsel. I object to the examination of compass.
Yes, sir.
So if the man comes if he comes down to the jail, report about me is a lie. I'm not going to even talk to him. I'm not coming out. I'm not going to talk to him.
I understand, but he's going to come and attempt to talk to you.
My constitutional rights are being violated. My 14th Amendment rights are being violated. So if he comes, I'm not going to talk to him. And I don't feel, I'm in fear that I can't even get a fair trial inside this courtroom. So I got other motions that I already got waiting. I just got to get it.
So, Mr. Lloyd, I just want to be clear about one thing. I haven't appointed Mr. Whedon to be your lawyer because you don't want him to be your lawyer. I've appointed him to be. No, it's not. I've ordered him to be standby counsel so that if you want to ask him at times for advice, you may do so. So otherwise, he's going to sit there like he's been doing today and quietly and observing, but he's available if we get to a point where you need some counsel about the law, then he can assist you. And if you were to change your mind, it's logical that he would then step in and take over your defense. But so far, I've permitted you to represent yourself and make that choice, which you do have the right to do under the Constitution of the United States. I advise against it for you and everyone who is in your position, that is being prosecuted in a criminal court because it's complicated and difficult. It's a choice you can make and you have made, but yes, sir, and I respect that. As standby counsel. Well, it's not legally the same thing. All right. Well, we see it a little differently. But both of your objections are noted for the record and preserved. So I'll see you next Monday. Mr. King, see you next Monday. Mr. Whedon, if you'll be here too. Thank you. All right, we're in recess. Thanks very much. Yes, and check with JAC and start to bill. Are you aware of that? Check with JAC. So we'll start to bill. We actually bill. You should keep track of it. You can bill. Try that.
Yeah.